Good afternoon, everybody. Today is Wednesday, July 15th of 2020. This is another installment of the Wednesday live meetings to discuss a topic of the law that some people may have interest in and answer any questions anybody may have. Again, my name is Bob Probst. I'm with the Probst Law Firm in Winston-Salem, North Carolina. And today's topic is Chapter 13 bankruptcy proceedings in North Carolina. As you recall, last week we spoke about the Chapter 7 petition and the advantages and disadvantages of that, and the steps and processes for being able to do that if you decide that's what you want to do, or if you know someone who may be thinking about that. This week we'll talk about the Chapter 13 proceedings, the advantages and disadvantages of that, and whether or not what the steps and the processes are for that. As I mentioned last week, there are pretty much two basic types of bankruptcy filings for individuals, Chapter 7 and Chapter 13. So the first thing I want you to remember is the same thing I told you last week, which is the bankruptcy code was written so that people can get a second chance at financial freedom. It is designed to allow you to work through your debts so that you can come out the other side and have a better life financially, which of course will lead to less stress in your life and allow you to have a much happier life. So people should not be afraid or embarrassed to use the bankruptcy laws because they were created just for those situations. And there are a lot of famous people, a lot of famous business people who have utilized the bankruptcy laws so that they can get to the other end of some financial stress they're under and move on and begin again. So, okay, first of all, when is Chapter 13 used as opposed to Chapter 7? So you might want to use Chapter 13 if you don't meet the means test that I discussed last week in Chapter 7. Just as a refresher, the means test is a test you have to take if you're thinking about filing bankruptcy, where basically in a nutshell, you take the last 6 months of your average wages, or the debtor takes at least the last 6 months of their average wages, and compares that to the median income for a household the same size in the location where the debtor will be filing. So if a debtor has a household of 5, you're going to compare that income with the median income of the household of 5 in the same location. And that median income has been determined by Congress. And as you recall, if you are below that median income, you're probably going to be able to file Chapter 7. If you're equal to that median income, you're probably going to be able to file Chapter 7. If you're above that median income, you can try a second way to qualify for a Chapter 7, or you may be forced into the Chapter 13. So that's maybe the first reason why you might file a Chapter 13 over a Chapter 7 is because you failed the means test. You earned too much to qualify for a Chapter 7. Another reason you might choose Chapter 13 over a Chapter 7 is if you own a home that has a mortgage, or you own cars that have car payments, and you're behind on that mortgage, or you're behind on those car payments, and you can't get the money up to bring those debts current before you file your bankruptcy petition, then you're going to need to go to a Chapter 13 if you want to keep those assets. So in some cases, you can, if you're a month or two behind, you can catch those payments up. You still might qualify for a 7 and be able to keep the home. However, if you can't get the money to be able to bring the debt up to balance before you file, then you're going to have to look at filing a Chapter 13. Another reason you may want to file a Chapter 13 is because you may have more equity in your home than you're allowed to exempt in a bankruptcy petition. So basically, and we talked about this a little bit last week, North Carolina allows you to exempt certain property from being taken in a bankruptcy and sold to pay the creditors. That's called the North Carolina exemptions. And they have values for those different types of property. So you might have more equity in your house than you can protect under the North Carolina exemption. If you do, again, you're going to probably end up wanting to file a Chapter 13 so you can continue to keep your house and make the payments. And that's particularly true if you want to keep the assets rather than forfeit them. The steps and processes for filing a Chapter 13 petition are very similar to the ones for Chapter 7. There's kind of one additional one, but they're very similar, okay? The first step is, number one step is determine if you qualify for a 7 or a 13 and which one advantages you more given your financial situation now and what it is you're trying to gain as a result of filing the petition. What is your goal? What is your outcome that you want to have happen? Find out, determine whether you qualify for a Chapter 7, and then determine whether that 7 is better for you or 13 is better for you. Step 2 is, as I mentioned last week, in 2005, I think it is, Congress enacted some debtor counseling that needs to happen before you file bankruptcy, and then again before you're discharged from the bankruptcy. So step 2 would be to take your pre-filing debtor course. Good news is that debtor course is an online course. You take it from the comfort of your own home. When you're done the course, it downloads a certificate saying you successfully completed that course, and you'll file that along with your petition. The whole thing runs anywhere from $30 to $45, and it's pretty simple to take. Step 3 for filing a Chapter 13 petition in North Carolina is to complete the actual petition forms. And just like in Chapter 7, they're very complicated, very large amount of forms or schedules that you have to complete. And what they're doing in those schedules is having you list every source of your income, having you list every asset you own or have an interest in, breaking it down by the type of asset it is, having you list what the value of that asset is, listing every one of your debts, everything from a credit card to a mortgage to a car loan to a personal loan, whatever you may have, breaking those down individually, listing those, listing how much the debts are, how much the monthly payments on those debts are, and the names and addresses of the creditors. And it's very important to get the names and the addresses of the creditors correctly because they're going to get notice of you filing your Chapter 13 petition. What many people do, and most attorneys will have you do, is to download a copy of your credit report, because your credit report generally has every creditor you have on there and how much you owe them. You can always get a free credit report at freecreditreport.com, but you can also sign up with internet with Credit Karma, K-A-R-M-A, and you can get reports there as well. Credit Karma doesn't always have exactly every debt on there, so you want to double check, but it's free and you can get it as many times as you want versus looking in freecreditreport.com. It's typically one time a year. Then you get that paperwork together, you complete all those schedules, and you get all of the supporting documentation you're going to need. So you're going to have supporting documentation, and the instructions for the petition will talk about that. A supporting documentation for all of the assets you own, what the values of them are, all the income you have, where you get it from, and all the debts you have, what do you owe and who do you owe it to. And you put that all together in a big package and you file that with the bankruptcy court. And these days, at least in North Carolina, all those filings are pretty much done electronically, usually from the attorney's office, so you don't actually have to go down to court anywhere. Once that bankruptcy petition is filed, that stops all creditors trying to collect from you. So if you're getting phone calls, that will stop the phone calls. If you're getting letters, that will stop the letters. If you've been sued, that'll stop the lawsuit. And if you have foreclosure, for example, pending on your house, already set up, that will stop the foreclosure. So if you're in a position where next week your house is going to be foreclosed on and you have no place to go, that may be a time for you to get in, see an attorney, get a Chapter 13 petition filed, or Chapter 7, depending on your circumstances, and keep that foreclosure from happening. That's called an automatic stay. And as soon as you file your petition, you get an automatic stay. Your creditors can no longer try to collect from you unless they do it through the bankruptcy court. And that's why it's so important that you get the names and addresses of your creditors correctly so that you can get notice to them so that they will stop trying to collect from you. Once the petition is filed, a trustee, which is usually an attorney, is appointed to review your petition and to look in to determine whether or not the Chapter 13 is the right petition for you, to look into whether or not you're listing your assets correctly, you're listing your debts correctly, and if there's anything suspicious or concerning about, he'll reach out to your attorney and he'll go through anything that looks a little different than in most petitions. But that bankruptcy petition trustee sort of takes over your file from there, representing the creditors, to try to collect as much money as they can for the creditors, and is the liaison between you and the bankruptcy court, along with your attorney. A little different in Chapter 7 than Chapter 7 proceedings is in the Chapter 13 proceedings. Remember, it's about reorganizing your debt, not just discharging it. In Chapter 7, your goal is to not pay another penny on your debt and discharge or get rid of all of it. In Chapter 13, for various reasons, you're not really getting rid of the debt. You're reorganizing the debt. You're reorganizing your payments so that you pay them over a period of time. And you're certainly going to end up paying a lot less than what you would pay if you were not in bankruptcy. Certain priority creditors are going to get paid in full. Secured creditors might get paid a little bit more, but your unsecured creditors might get paid as little as 10 cents on the dollar. But what's going to happen when you generate that petition is it's going to generate a proposed plan that you're proposing to the trustee that says, given my income, given my assets, given my debts, I'm proposing that I pay X amount of dollars a month towards my debts. And that plan is probably going to propose that you do that for 3 to 5 years, most likely 5 years. So you're going to be in the plan for 60 months. Remember, Chapter 7, you're going to be able to get out in about 6 to 8 months and be done. And in Chapter 13, you're going to have to stay in the plan for up to 60 months. And if that trustee accepts the plan, then you're going to make payments into the plan of whatever your proposed plan and the amount your proposed plan says. And then the trustee is going to be the one who's going to pay the debtor, the creditors, not you. So you'll make your one payment into the plan, and then your trustee will make the payment to your credit card people, your bank people, your car loan, your mortgage, that kind of thing, typically. Sometimes you pay your mortgage outside, but most of the times you pay it inside the plan. And you will do that for that 60 months. Once that 60 months is over, or if it's a shorter plan, once that time period is over, then whatever debts remain are discharged, and you're dismissed from the plan. You're dismissed from the bankruptcy. But that also means that you're sort of tied into being involved with the bankruptcy court for the next 60 months, which may mean in a lot of cases you don't do anything but pay your money. It may mean at some point you get behind again, so you're going to have to go back into bankruptcy court and try to figure out what you're going to do next. It may be that your car that you had when you started your bankruptcy petition 3 years down the road breaks down and you have to get another one. So you might have to go back to the bankruptcy court and ask permission to borrow money to be able to get a new vehicle or to get another vehicle. So since you're in it for the next 60 months, there may be times when you're going to end up having to go back to court for things to be decided. Then your fourth step in a Chapter 13 proceeding is you will go to a 341 creditors meeting, just like in a Chapter 7 proceeding. That 341 creditors meeting takes about 10 minutes. The trustee will ask you questions about your petition. There may be a creditor or two there who's going to ask you about your petition. But it generally is pretty informal. It takes about 10 minutes and then it's done. You may be asked, just like in a Chapter 7, to reaffirm a debt, which means if you've got a car loan or a mortgage, they may ask you to reaffirm that debt, which means sign a new document saying, I agree to continue paying that debt. And then, of course, if you've done that and you fail to make payments, then they may be able to come and take that assets, even though you had filed bankruptcy. So that's something for you to go over with your attorney. Once the 341 creditors meeting is over, then the plan will be sent to a bankruptcy judge, and there'll be a hearing in front of a bankruptcy judge. That's the fifth step. for the filing a Chapter 13 bankruptcy petition. The fifth step is the hearing before the bankruptcy judge. You don't do that in a Chapter 7, but in a Chapter 13 you do. Then the bankruptcy judge goes over the petition. You're there, your attorney's there, and other court personnel and any creditors if they want to be. But basically, you're going over that petition one more time with a judge, and a judge either approves the plan or does not approve the plan, or asks that the plan be modified or something. The majority of the time, they approve the plan. Then you're done any of your court proceedings, unless, of course, like I said, you find yourself having to go back sometime during that 60 months so that you can either get permission to borrow money to buy a different car, or some other situation comes up that you need to deal with. And then the sixth step for filing a Chapter 13 petition is the discharge. In Chapter 7, that discharge is going to happen 6 to 8 months in. In Chapter 13, it's going to be more like 60 months out before your discharge. But if you successfully meet all the requirements of your plan, which is for the most part, you make the payments on time that you need to make, and then those creditors get paid, you're going to be successfully discharged at the end of the 60 months, or if it's for a shorter period of time, whatever period of time that is. And then you are done with the plan. You are done with any remaining debts are discharged, except for those like a house mortgage or a car payment. If those security interests or payments go out beyond the 60 months, you'll continue to make them, but you'll have gotten rid of your unsecured debt and things of that nature. Now, just like in Chapter 7, there are some debts that cannot be discharged in Chapter 13. Those are things like recent tax amounts you owed Uncle Sam. There are child support payments. There's a lot of spousal support payments, student loans, things of that nature. But mostly your unsecured debts will be gone at the end, and maybe even some of your secured debts. So that's Chapter 13 in a nutshell on the process. If you know someone who is struggling with the economy these days, or maybe you are someone who's struggling with the economy these days, it's something you should at least look into. It's a very difficult topic, I know, for people to come out and talk about. It's difficult for people to take the action to go see an attorney to see whether they even qualify, and if they do, what that looks like for them. But it is a process that we find with most clients that after they've gone through it, they're glad they did. The stress and pressure and sleepless nights that they have prior to filing are way worse than what they're going to feel after filing. So I just encourage you to go see an attorney of your choice, see whether or not it's right for you, find out what it would look like for you. Again, I'm Bob Probst with the Probst Law Firm. You can send me an email at bob@probstlawfirm.com. Give me a call at 336-721-9090. Visit our website at probstlawfirm.com. This is the end of this week's Wednesday class. If you have a subject matter you want for me to cover one Wednesday, feel free to post something on our Facebook page, Probst Law Firm, or shoot me an email, or make a note on our website page. That's it for today. Everybody, stay safe. Peace.